As estate planning lawyers who also do probate, we see a ton of mistakes in how people create a last will and testament. A lot of our clients that come to us for probate, they did their estate planning either with another law firm or on their own. And so they self-created or DIY'd a will for themselves. And there's generally several different mistakes that we see in the creation of a will. First is that the will document itself was not executed appropriately, following proper formalities for a legal execution of a will in North Carolina. We generally have to have a written will that is signed by the testator, it's the person creating the will, and is witnessed by two independent people who are not named to be an executor or beneficiary of the will. When that will is also notarized, that all three signatures, the testator, both witnesses, their signatures are notarized, then it's what's called self-proving, meaning when we submit it to probate, we don't need to go get an affidavit from these witnesses proving that they actually were a witness. Obviously, that can be pretty difficult later in life if we're no longer in contact with these witnesses or if they've passed away. Another issue that we'll see with wills is trying to do too much with the structure of the tool itself. For instance, some people will make reference to 401k benefits or IRA benefits or life insurance benefits as to who's supposed to get those different assets in their will, even though the beneficiary designations are already filled out on those assets. To the extent a financial designation is filled out and that person does survive you, the designation is going to control and it will trump what the will says. Next is trying to use a will to avoid probate. That's a very common misconception around the use of a will. Is a lot of people think that creating a will is a way to avoid probate, but all it does is clarify what's supposed to happen through probate, who your executor is and who your beneficiaries are. But it's still a probate driven process. And so it can obviously take a while to implement, up to 12 months in a lot of different circumstances. Trying to make the will more encompassing than what it naturally is. When we do will planning, we end up creating really two paths of wealth transfer. It's what the will controls and then what the beneficiary designations control. And so some people try to do too much with the will, allow it to hold assets that are not controlled by the will at all, and make it more prolonged distribution over time. So a lot of what we try to do is pick the right tools, given the goals that you have, the finances and the family considerations that you bring to the table to make sure that what you want to happen will happen whenever you pass away.